So now we have another session by Dr. Manoj Kumar Padhi, Faculty of Law. So wherein when we started with this particular training program, when we started planning this particular training program, we wanted to make our participants aware about what is the need for having the legal awareness. So because just by having legal awareness, what kind of changes that can be brought into the entire system. So that was the basic thing. So with this, so now I invite Dr. M.K. Padhi sir, who is Senior Professor of Faculty of Law. Basically, he deals with a number of issues associated with agriculture as a teacher. He teaches the agricultural insurance also, and he helps us in many occasions, especially the what are the forms and formats required for establishment of the agro-based enterprises, and so how to deal with the procedural aspects, and all these things are his areas of specialization. So he has already put in about more than 20 years of experience at Banaras University. So with this brief introduction, I now request Dr. Manoj Kumar Padhi sir to continue with the session.
Need for legal awareness on agricultural legislations. First of all, before discussing the legal awareness on agricultural legislation, the first thing that we have to discuss is, the first thing that we'll consider is, what is the need of, what is the benefit of legal awareness? It is not rolling. Yeah. You see, need of legal awareness. Forget agriculture for a moment. Legal awareness makes a person to know his or her rights, and legal awareness also enables a person to know the role, activities, and functioning of the legal service institutions. There is a maxim, ignorantia facti dot excusat, ignorantia juris non excusat. It means ignorance of fact is excused, but ignorance of law is not excused. If I do not know agriculture, I have not studied agriculture. If I do not know agriculture, I may be excused. If I do not know medicine, I may be excused. If I do not know engineering, I may be excused. But if I do not know law, I may not be excused. If a person who is an accused pleads that he is unaware of that particular law, and had he known the law, he would not have committed the offense, then the court will say mistake of law is not excused. Mistake of fact can be excused, but mistake of law cannot be excused. There is a very interesting case, Chirangi versus State of Madhya Pradesh, where a man was seen accompanying with his son to the jungle. People, they have seen that the person was going to the jungle along with his son in order to collect the forest products. After some time, some people, they saw that the father was running. The father was making him escape. The father was escaping himself, and the son lying dead. When he was prosecuted, he took the plea that he killed the son. He killed his son because there was an anticipation that a tiger was coming, and in mistake of fact, he killed his son. And he could able to establish this fact that he killed his son by mistakenly believing him to be a tiger. And he could establish beyond all doubt. And the court excused him. Had he pleaded the ignorance of law, he said that I'm a layman, I have never been to school, and I've never studied law, and I do not know committing murder is a crime, so I may be excused for the ignorance of law. Then he would not have succeeded. He succeeded for the reason that he was suffering from mistake of fact, but not a mistake of law. So, my learned participants, I would like to make it clear that ignorance of law is not excused. If you are not getting anything, or if you are not able to get the benefit of some project or some benefit of some government policies, then if you plead that it happened due to the mistake of law, then there is no excuse. Now, a question arises, why such a presumption? Mistake of law is not excused. The law is very vast. Law is very vast. They see that we are all learned person, and that the chairman was trying since last session to make us understand as what is CDAT and number of doubts raised. It occupied a whole session, CDAT, to understand for a learned person, for like us. Right? How is it possible for a layman, for a person who is illiterate, never been to school, to understand, to know each and every law? Why law takes such a presumption that all law must be known to all? Why such a presumption? That you may ask this question, that why this presumption that every person should know the law? Every person is presumed to know the law. Every person must be legally aware. Why such a presumption? The answer of this question is, why this presumption? Because law, the primary source of law is not legislation. The primary source of law is not the judicial precedent, what the judges say. The primary source of law is human consciousness. In every family, in every day, there is a court. There is a court. For example, that a farmer, the two sons, they struggle. The two sons, that there was a quarrel. There was some conflict between two sons. The younger came to the father, complained that Bhaiya ne mara. Then you know what the father does? The father first give an opportunity to the victim. The father give an opportunity of hearing to the victim. The elder will try to plead his defense, but the father said, no, let the victim speak first. Father hears the victim. Then father gives an opportunity to the elder to defend his position. In law, we call this odi altum partem. The farmer doesn't know what is meant by odi altum partem. Every person must be given an opportunity of being heard. The farmer doesn't know this. It came from the inner consciousness that no, each son must be given an opportunity of being heard. Then the elder put his words. Then the father called the witness mother. Come, what happened? माँ को बुलाया जाता, क्या हुआ बताओ जी? Mother gave witness, and after that the father gave the verdict. Who ever the father? Who educated the father to listen to both the parties, and before giving decision rely on witness, rely on evidence? What we teach to our students, what the judges do after qualifying such that examination, judicial examination, after having so many experience, the judges, what they do, an illiterate farmer has done in his own house. So in every court, in every family, there is a court. And even a person who has never been to school, he knows that murder is an offense. It's a wrongful act. He may not be knowing the quantum of punishment, but he he must be knowing that what he has done is wrong and what he has done against law. He has never been to school. He has never studied law. But after committing a crime, every person is knowing, every person knows that what he has does is against the law. It's not good, against the law. So he starts escaping. He avoids arrest because he knows what he did. Therefore, as the primary source of law is human consciousness, so it is presumed that every person knows the law. But at the same time, it is the duty of the state, the state duty to spread legal awareness. It is not, the state cannot be justified by avoiding its responsibility, merely saying that law is there in human consciousness, so our duty is over. No, state's duty is not over. The state duty is to make the people aware of their rights, aware of the law. So for this reason, we are assembled here, and we are here to make us aware about the different legislation on agriculture. You know, what is the, or let us say, what are the benefits of agro-legal literacy? I've used the word agro-legal. I have not seen used in any of any article or any book the word agro-legal. I have used that in the line of medico-legal. The medico-legal, that, you know, one of the subject I'm teaching in Faculty of Law. In that line, I've used this word agro-legal. I don't know whether it is 100% correct or not, but I think it's correct. Benefits of agro-legal literacy. What are the various benefits? You know, that legal empowerment, it can generate this self-respect. Legal empowerment can play a significant role in ensuring respect and protection of rural man and woman rights. Particularly when we are talking about agriculture, then definitely the thing that comes to our mind is the rural farmers. And the legal empowerment enhance their food security and livelihood, helping the poor get out of poverty. These are the survey, or these are the concluding remarks, or these are the remarks of FAO, Food and Agriculture Organization of the United Nations. That what are the benefits of agro-legal literacy? That what happens if a farmer being aware of the law, if then what are the various benefits? The next benefit is overcome economic inequalities. This is, you know, economic inequality is a great hindrance before a nation's development, and it is believed that the legal awareness will eradicate the economic inequalities. The legal empowerment has an ability to create economic opportunities. If you know the law, for example, under the Companies Act 2013, provisions are there for establishing entrepreneur. The later part of my that slide will make a brief of that. That if you know the law, you can establish, you can create enterprises of different qualities of your choice. Or the one of the thing was, I was noticing, we will study about the farmers producer company. It's called producer company by the farmers. If you know the law, how to register a producer company, if you know the law, how to register a partnership, if you know the law, how to register a company, okay, then definitely it will open the economic opportunities, and it can improve the access to credit and financial services. It's needless to say. As I've already told you that what I was telling the remarks of a Food and Agriculture Organization of the United Nations, and the FAO is continuously trying to make the farmers, particularly the rural farmers, to know about the agricultural law. And the FAO has also submitted that what farmers got after being aware of law. What advantage the farmer received after knowing the law. You see, the FAO's observation, the FAO experience at the country level indicates that paralegal training programs are viable approach to improving respect for and ensuring protection of people's rights to land and other resources. And I will corroborate this in next part of my slide. These programs increase capacity at the country level to influence institutional and legal reforms and to implement reforms in practice. Doing farming with the knowledge of law is just sunete suhaga. That you know the law and involved in farming activities, then you know many of the problems you can avoid. Furthermore, according to FAO, paralegal training programs can also contribute to improving gender equality in agriculture. This is a very important thing, gender equality in agriculture. You know that one of the most important thing what I have learned, now the women participation in agriculture is going on increasing day by day. And at this juncture, it needs the eradication of gender biasness in agriculture. For example, the minimum wages, etc. And the legal awareness also will strengthen women's access and rights to land and other resources and services and their participation in decision-making process. This is very important because, as I have already stated, that the women's participation in agriculture is going on increasing day by day. I'll make it clear. As a student of land law, I have studied the various state land laws where there is gender discrimination still prevails. Hindu Succession Act 1956, when it was originally enacted, it was gender biased. Son was placed in first class here, and thereby forfeiting daughter's right in father's property. In 2005, there was an amendment in Hindu Succession Act, and daughter was elevated and placed at equal par with the son. But still, the land laws, they are gender biased. For example, if I'll talk about the Uttar Pradesh land law, because land law is a state subject, so the different states, they make their own laws. And just I would like to give an example of Uttar Pradesh Revenue Code 2006. Under Uttar Pradesh Revenue Code 2006, there is a discrimination between married and unmarried daughter. Inspired by the Hindu Succession Act, the unmarried daughter was placed at par with the son, but married daughter is excluded. Married daughter is excluded. It means the act spreading a message that if you will marry, you will lose. You remain unmarried. That's all. And at the same time, it also spreading an unethical message that do whatever you like, except marriage. You can go for a live-in relationship. You can continue a illicit relationship, but don't marry. If you marry, you will lose property. You lose your share in father's property. Hindu Succession Act, for your kind information, doesn't discriminate between married and unmarried daughter, but land law made a discrimination. And not only that, that under the Uttar Pradesh Revenue Code 2006, if a male inherit agricultural land from the father, then the interest of the male in that agricultural land is unlimited. He can sell, and after his death, the land will develop, the land will inherit to his own son or to his own successor. But if a female inherit agricultural land from her father, then her interest is limited. Limited means after she marries, the land will go back to the deceased father and thereby inherit to the nearest heir of the father. So this is a limited interest given to the female till today. When you know that we have done tremendous work to abolish the gender biasness, but still our land law is, the gender biased. And this we can only know after becoming legally aware, because the women participation in agriculture is going on increasing day by day. So the legal awareness can enable that women farmers or women laborers to know about their rights. That is this is a the program I'm talking about. That is a project of FAO. That is it is the a legal awareness program, CFJJ FAO program. Is started in 2010 and funded by the Norway, and it focuses on the issue of gender and women's right over land. Paralegal programs specifically for women's NGO are being run, with follow-up provided for the paralegals when they go back to the communities where they work and begin the challenging task of changing attitudes and, where possible, seeking to adjust local practices to bring them into line with overarching constitutional principles on the equal treatment of women when it comes to land and resource access. So FAO came to a conclusion that when that some legal awareness program, particularly the agro legal awareness program, was initiated, it made some change. Okay, the participants, after they return to their return to their own area, they were much comfortable. Okay, they were much comfortable in farming. That more recently, the Food and Agriculture Organization has focused on bottom-up empowering men and women farmers through its farmer field and life school approach. This is also a kind of a legal awareness project, FFLS project, farmer field and life school project. And based on the participatory agriculture extension approach of farmer field school is a learning process aiming at empowering farmers to understand the larger socio-economic and cultural context and factors which influence their lives and livelihoods. And that is the benefit of these programs. The first experience of using this approach for raising awareness of the farmers on legal issues and strengthening their capacity to use law and legal services has been experimented in Kenya at the coastal province, and this FFRH project implemented in 4 coastal districts in collaboration with the Association of Women Lawyers, uh, and it successfully integrated a number of legal issues in their participative training, and particularly most of the training program, it included reproductive rights, gender-based violence, property rights, and children rights. You know, one most important thing, and I like to convey to my learned participants. Actually, when I say that women participation or in the agriculture is going on increasing day by day, merely making them aware of agro laws is not sufficient. They need to aware about the reproductive rights. When in the village, that due to lack of awareness, okay, and most of the thing you'll find a woman is being treated as a child making machine. She doesn't have any choice at all. Whenever husband requires that I need a child, okay, that decision is fine. So women, they need to know about the reproductive right, a new branch of law, the right to become mother. It is her choice. It is her body. It is her choice. This is a right to self-determination. Women should know about this. It's a reproductive right. If she has a career, then she said that, no, I do not want to become mother. It is her choice. Gender-based violence. India, we have the Protection of Women Against Domestic Violence Act. All women farmers, they need to know this law. ऐसा नहीं कि आके जो है पति रात को शराब पी के तो आके उसके साथ बदतमीजी करें, अनपार्लियामेंट्री लैंग्वेज उसको यूज करें. So she should know the law, and particularly the Protection of Women Against Domestic Violence Act 2005 is very important act, which make a woman. Suppose you know the 498A Indian Penal Code, cruelty. It was already there. 498A. That husband committing cruelty, the wife lodges FIR, and that husband being arrested. But what is happening to the wife? The father-in-law, the in-laws, they were simply asking, go away to the father's residence. चले जाओ, तुम हमारे बेटे पर FIR दर्ज कर दिए, तुम घर में नहीं रह सकते, जाओ, भाग जाओ. वहां पिता के घर जाती है तो पिता कहता है कि नहीं भाई, ये तो डोली पिता के घर से उठेगी, अर्थी तो ससुराल से उठेगी, तुम यहाँ कहाँ आ गई? Our responsibility is over. When that we manage to send you to your in-laws house, our responsibility is over. Now we will not accept it. So most of the domestic violence cases, जो कि रूरल में बहुत ज्यादा होता है, and many women farmers, they are the victim of the protection of home, that the domestic violence. They do not complain for the reason that if they complain, they will be ousted from the in-laws house, and the father will not accept. This Protection Against Domestic Violence Act 2005, it gives civil remedy to the victim. It says that if your in-laws oust you, if they kick out from the house, then it gives the victim remedy, civil remedy. जो कि आईपीसी में, जो क्रिमिनल लॉ में नहीं था. क्रिमिनल लॉ में ऑफेंडर को पनिशमेंट था, लेकिन विक्टिम को सिविल रेमेडी नहीं था. अगर उसको घर से बाहर कर दिया जाता है या उसको खाना पीना बंद कर दिया जाता है, तो उस समय उसकी सिविल रेमेडी नहीं था. जो प्रोटेक्शन ऑफ वुमेन अगेंस्ट डोमेस्टिक वायलेंस एक्ट में 2005 में, सो द not only the agricultural laws, that with all that respect to the organizers who have that framed this, that the different agricultural laws need to be studied, need to be discussed in this training program. I'd like to suggest that let us have some very general law like protection of women against domestic. If a woman lover is a victim of domestic violence so can we expect that she will go to the field and work her best, will give her level best in the field? No, never. So awareness of agro laws are not sufficient. These important laws, particular property rights. I have written an article on the property rights of women, particularly in the agricultural land. And I find there is a great deal of gender biasness. There is a great deal of gender discrimination in land rights of women. This has to be informed to the woman, apart from the agro laws and children's rights also. What are the various children's rights? This should be informed to the women farmers. And when I am talking about farmers, simply if I leave the women farmers, then definitely I'm leaving 50% of the population. So much of my work is based on this women farmers and the laws relating to, in general also I have discussed, but emphasis on the, what I said, the women farmers. And you know, according to an FAO case study undertaken to document this experience, the paralegal training generated several positive effects. FAO has experienced this, that it has generated some positive experience. Inter alia, a number of trained persons started providing advice to the neighboring communities. Very good, very important thing. That those who became aware, they didn't give the knowledge within themselves, but rather they disseminated. They shared their knowledge to the communities. But our learned participants are here. Okay, that if after learning something, if we disseminate, if we share, then that would be the objective of this training program. They inform the widows about their property rights, and some facilitators provide assistance to village orphans by ensuring that they attend school and by protecting their property. In few cases, the increased awareness on legal rights and available legal services has served as a protection against dispossession of widows. I would like to tell you, in Uttar Pradesh, some of my participants might be from Uttar Pradesh, and it is that almost similar in mine may be a slight departure, but the state, because I have studied the different state laws, you know, in Uttar Pradesh, under the Uttar Pradesh Revenue Code 2006, widow inherit after the husband's death. If husband died, widow inherits husband's landed property. But if a widow remarries, if that widow remarries, I told you that if widow being a female, her interest is limited. So if widow remarries, then widow will be ousted from the land title what she has received from her deceased husband, on the presumption that she is getting a new home and a new right in after the remarriage. After remarriage, she may not have, the second husband may not have that much landed property, where our society is facilitating, encouraging remarriage of widows, but law discourages widows remarriage. If you marry, you will be divested from the land what you inherited from the father, from the husband. You know, definitely that as my point of observation, that and as I've studied the various land legislation, and I've studied some literature on the India's past, that agriculture in the history, and I came to a conclusion that India is happy when farmers are happy, because being an agro-economy country, we can't develop if our farmers are not happy. And if you want to make us farmers happy, then we have to make them legally aware. Because one of my lectures is already there, that in that I'll explain you the history and that is, but I have my own opinion that if farmers are happy, then India happy. Okay, and in Hindu period, farmers were happy, and that attracted the Muslim invaders to that invade India. You know, farmers are committing suicides. Suicide of the farmers in India is not a new phenomena. Okay, and if we see uh, the government data, okay, the Crime Record Bureau, National Crime Record Bureau, NCRB, National Crime Record Bureau, and 2019 data are available. And the 2019 data, according to, you can see 10,281 person involved in farming sector committed suicide. Okay, in 1 year, 7.4% suicide victims out of this total. Farmers, particularly, okay, 556 male and 394 female. The total person who were related to the land, the farming sector, and who committed suicide, farmers, only farmers, that is 5,957, and cultivators 4,324. A total 10,281. Okay. It is one of the reasons. That many reasons are there, and that the next slide will explain the various reasons why the farmer commits suicide. And this is the 2015 data I have, and bankruptcy and that is indebtedness is occupying a major cause of farmer suicide, and apart from other things are there, and most of the things, most of the causes, okay, they can be minimized, okay, they can be eradicated up to some extent, okay, after making the farmers legally able, okay. These are the state wise distribution of the farmers are cultivated. The died during 2015, Maharashtra was leading the list, and with this we now will come and we'll discuss the various legislations. Now we have discussed the benefit of that is just legal awareness, particularly relating to agriculture. Okay. Now we have the list of the laws, okay, that we have relating to farming, relating to agriculture. List of law, but I say these are only the agro-related laws, farming-related laws, but apart from the farming related laws, as I have already told you, other general legislations are also there, like Protection of Women Against Domestic Violence Act, which directly interferes the production, which directly interferes the the farmers' interest, particularly the women farmers' interest. Many other laws are also there, but pure laws on agriculture. If you ask me what are the pure laws on agriculture, then I have, I have a list of the laws which applies to farmers, agro-related laws, farming-related laws. But again, I say this may not be the exhaustive list. This may not be the exhaustive list. I have made an attempt to to include as much as possible, but there may be some law which may be escaped from the list. This is not an exhaustive list. Indian Constitution always talking about the upliftment of the poor, okay, protection, environment, eradication of inequalities, okay, all aims to, these are all, if not directly, indirectly, they talk about the farmers' upliftment. Indian Contract Act 1872, these are the central legislation. Indian Contract Act 1872, a British-made law. And you know that after these three, that is the farm laws which are in dispute, okay, whether that is farmer can sell the commodities, okay, outside of the mandis, And for that, the farmer need to enter into a contract. And for contract, that the farmer need to know the law relating to contract so that he may not be exploited in contract. Okay. Laws relating to fertilizer, Consumer Protection Act 2019. I'll make a brief of the laws. Okay, in next slides. Uttar Pradesh Revenue Code, I'm talking about 2006. Uttar Pradesh Consolidation Act 1953, SEED Act 1966. That is our respected chairman was talking in the first session. SEED Act 1966. Protection of Plant Varieties and Farmers Right Act is there in some session. In some session, we will discuss this. Okay, that Plant Varieties and Farmers Act. Many of these agro legislations they are being chosen by the learned organizers, and they will be discussed in different sessions. But just I have chosen some of the things which are missed, accidentally missed by the organizers. Only I will discuss on that only. Okay, and because most of the things they are already been included in your in your course curriculum, so you will be discussing all this, like Protection of Plant Varieties and Farmers' Rights Act 2001, Insecticides Act 1968, the Standards of Weights and Measures Enforcement Act 1985, Agricultural Produce Grading and Marketing Act 1937, Bureau of Indian Standards Act is also called BIS 2016, Food Safety and Standards Act 2006, which repealed the Food and Adulteration Act. Okay, you will study. And some that is agro related laws relating to that labor laws, like Industrial Dispute Act 1947, Factories Act 1948, Minimum Wages Act 1948, the Child Labor Prohibition and Regulation Act 1986, Modern Labor System Abolition Act 1976. All are, I think, they will be discussed somewhere in that during this course. The legislation in livestock sector, including the Livestock Importation Act 1898, Glanders and Fussy Act 1899. This is, Glanders and Fussy Act relating to the mercy killing of horses. That if any horse is suffering from any disease which is contaminated to human being, then the horse can be killed under this act. Okay, that the mercy killing of horses. Glanders and Fussy Act 1899. Prevention and Control of Infectious and Contagious Disease in Animal Act 2009. Cattle Trespass Act 1871. Prevention of Cruelty to Animals Act 1960. These are included that the agriculture biotechnology, the application of biotechnology in agriculture, the genetically modified crops. That is very important. You might be discussing somewhere in this training program. Genetically modified crops. Law relating to agriculture credit and finance. This is also we'll discuss. WTO and agriculture negotiation. This is also we'll discuss. Tax on agricultural income. So today that you will be discussing this, that my learned colleague, Dr. Professor D.K. Srivastava ji, I think he will be dealing this tax on agricultural income today itself, I think. Law relating to geographical indication, that discussion was going on when I joined. That IPR and agriculture, patent, trademark related legal provisions, that is already there in your curriculum you'll study. Laws related to agriculture insurance, this I will be dealing in some session, I remember. Law relating to agriculture pricing and subsidies, this is also there in your laws related to export and import of agriculture commodities. Okay. And that apart from this, these are the various things that are included. Something other agricultural laws which are not adequately covered or may be covered. That Hindu undivided family. That if farmers they want to go for entrepreneurship, okay, for establishment of enterprise, then enterprise of various kinds are there. And depending on his choice, he may establish his enterprise. And what are the various kinds of enterprise? It may be a Hindu undivided family. Okay, it may be enterprise. It is a kind of enterprise. Partnership Act 1932, a partnership which is being that established under the Partnership Act 1932. It's a kind of enterprise. Or he may go for a cooperative farm under the registered under the Cooperative Society Act 1912, or he may register a company under the Companies Act 2013. Okay, so these are the various things. These are the various laws that one need to know in order to go for entrepreneurship development. Okay. Okay, that as I've already told you that there are some laws, because it's the constitution which decides that which law will be, constitution has divided the three fields. One is union, one is state, and one is concurrent list. The subjects which are placed under the union list, only the center can make the law. The subject which are placed under the state list, only the state can make the law. And the subject which are placed under concurrent list, both union and the state can make the law. And for your kind information, agriculture and land, they fall under the state list. So the state government is empowered to make the law relating to agriculture, relating to the, what I said, land is a subject of state, but agriculture is a concurrent list. Both center and the state, they make law on agriculture, but land is a state list. So only the state can make the law relating to land, including the agricultural land. But even though the state make the law relating to land, relating to agricultural land, the state is subject to the policies framed by the central government. For example, when the Hindu Succession Act was amended in the year 2005, the Uttar Pradesh land law also amended in 2008 to give remove the possibility of contradiction. The UP land law also amended in the year 2008. But as I said, the land, particularly the agricultural land, it falls within the state, but subject to the central policies. Now let us have the policies. Difference between law and policy is that the government, first, formulates a policy, and to effect the policy, laws are being framed. Okay. So now let us discuss what are the national policy on agriculture. What is the national policy on agriculture? That we are very safe because even any international negotiation or any international development is taking place, it will affect India also, because India is party to major agricultural organization, agricultural institutions like WTO. India has been a member of the WTO since 1st January 1995. FAO. India has been a member of FAO since 16th October 1945, and it was one of the founding members. International Plant Protection Convention. India signed the convention on 30th April 1952 and ratified it on 9th June 1952. The Office International des Epizooties, or this is also called the World Animal Health Organization. India is a member of this organization since 30th May 1924. So that if there is any vibration at the international level, okay, that will be reflected, that will be felt in India also, because India is a member to most of the organizations. National agriculture policy, the main emphasis is for a sustainable agricultural growth. A sustainable agricultural growth. So the word sustainable agricultural growth means growth of agriculture without degrading the environment. It's a sustainable agricultural growth without degrading the, the human civilization, without degrading the environment. It's called the sustainable agricultural growth. We you know that okay, fertilizers required, but not up to an extent that it will again risk. It will, no, fertilizers that they come directly or indirectly, they come to us through the food chain. Okay, but the national agriculture policy, the sustainable use of fertilizers, sustainable use of fertilizers. Scientific, the application, the next is to include the scientific and technological advancement, to use science and technology in agriculture. And the most important thing, use of bad technology. Use of bad technology. I think this will be covered in some of the session, and that would be a very important session. That use of bad technology, the future of Indian agriculture. You know, the agriculture export policy 2018, okay, and the aim is to boost India's agriculture exports to US $60 billion by 2022. And you know that is a part of the Corona crisis, that is Atmanirbhar Bharat Abhiyan, and other measures and various reforms are being contemplated in agriculture sector to make India the food basket of the world. You know about the recent developments that we all know, the Essential Commodities Amendment Act 2020 that we will discuss in some of the session, okay, which aims to remove the existing restriction on stocking food produce and provides freedom to farmers to produce, hold, move, distribute and supply food produce. We will be discussing in detail. So, and in brief only, I have narrated this. One other act which is again in highlight, the Farmers Produce Trade and Commerce Promotion and Facilitation Act 2020, which I am talking about also, aims to ease the restriction imposed by APMCs and that which promotes a barrier-free trade and allows the farmers to sell their produce to other buyers outside these mandis. Okay, and it also proposes for the creation of electronic trading transaction platforms. You know that there is one session we will be discussing that National Agriculture Market e-NAM. Okay, electronic National Agriculture Market that you will be discussing, and for that, you know, you need to that the farmers, they need to know about the law relating to e-commerce. The law relating to e-commerce, because when if they want, if they start selling their commodities through you know, through computer, okay, or through e-medium, definitely they must be aware of the e-commerce laws. And where do we find the e-commerce laws? That is under the Consumer Protection Act 2019. The Consumer Protection, the earlier Consumer Protection Act was of 1986. Now in 2019, a new act was enacted, repealing the old act, and under the new act, the provisions relating to e-commerce has been given. Apart from this, e-commerce provisions are also there in the Information Technology Act. Information and Technology Act. This is also called IT Act. You'll find the provision relating to e-commerce. Okay, so in order to check the exploitation of farmers, that when they start selling their commodities through online, then these laws will be helpful to the farmers. One more act which is also in the limelight, that is called the Farmers Empowerment and Protection Agreement on Price Assurance and Farm Services Act 2020, which provides a national framework on farming agreements or contract farming that protects and empowers farmers to engage with agribusiness firms, processors, wholesalers, exporters, or large retailers from farm services and sell future farming produce at a mutually agreed price by entering into direct contracts and enable farmers access to modern technology and better inputs. For 2020 Act, the farmer needs to know about the law of contract, which I was talking about, the Indian Contract Act 1872. The farmers, they need to know about the contract law. And I'll give a brief of the contract law also, that what a farmer needs. That is a law relating to contract. In this 2020 Act, the farmer will enter into direct contract with the buyer. The farmer will enter into direct contract with the buyer. And for contract, the farmer must have the basics of law of contract, because this is not covered under this curriculum, which I've seen the themes which are included in this training program. So just I'll make a brief of the contract law. In a contract law, few things are important. The first thing is that parties must be competent. Okay, both the parties must be competent. Okay, section that is 10 of the Indian Contract Act 1872 says, as to who are competent. Section 11 says the person who attain the age of majority, who attains the age of majority. So एक फार्मर जो 18 साल से कम है वो कॉन्ट्रैक्ट नहीं कर सकता. He can't sell the commodities. He must have attained the age of majority, 18 years. Second, he must not be suffering from unsoundness of mind. He must be of a sound mind. And third is, he must not be disqualified by law from contracting. Disqualified means, for example, person who is insolvent is disqualified from contracting. So, the first thing is that parties must be competent. The second thing, consent must be free. When a farmer selling the commodities to buyer through a direct contract, his consent must be free. And when consent is said to be free, Section 14 of the Indian Contract Act, Section 14 of the Indian Contract Act, it says when the consent is said to be free. The consent is said to be free when it is not caused by 5 elements. And if the consent is caused by these 5 elements, the consent is not free. And what are the 5 elements? Coercion. हिंदी में उसको कहते हैं प्रपीड़न, कॉरप्शन. कनपट्टी पर बंधक रख के कहता है कि इस कॉन्ट्रैक्ट पे साइन करो, इस एग्रीमेंट पे साइन करो. दिस इज नॉट अ फ्री कॉन्सेंट. This is not a free consent. Coercion. Secondly, अगर वो कहता है that if you will not sign on this agreement, I will destroy your crops. This is corruption. Second is undue influence. Undue influence means that where one party is at a higher footing and capable of dominating the will of the farmer. For example, if the buyer is a very rich person, very influential person, very big businessman, and the farmer is a poor farmer, and the farmer could not negotiate properly, could not bargain properly, and sell the commodities to the businessman with a very low price. Subsequently, the farmer can contend that his consent was not free because the other party was on a higher footing and could influence the will of the farmer. So he can avoid the contract. Similarly, misrepresentation. If the buyer commit any misrepresentation or if the buyer commit any fraud, then also the farmer can avoid the contract. And mistake. If the farmer signed an agreement and the farmer could not understand the English or could not understand the language used in the agreement and sign on an agreement, the farmer can later say that as he was signed on this agreement by mistake, the farmer can avoid the contract. He said it is not my contract because he was suffering from mistake. So the law of contract says, that for a valid contract, the consent must be free. And if the consent is not free, then the aggrieved party can avoid the contract. So therefore I say, the farmer, they need to know, if they will go for direct contracting, they need to know the law relating to contract. And for that, particularly the most important thing what they need to know, that is the consent, the law relating to consent. Okay, and not only that, it also says that if the agreement is unlawful, it is void. If the agreement is against the public policy, it is void. If the, for example, that if in many cases, you know, that the farmers, they enters into contract, and the agreement is against the public policy, and if it is against the public policy, then it is void. So the farmers, they need to know about these contract laws if they starting doing contract directly with the buyers. Consumer Protection Act 2019. You know, 1962, the United States President gave a historic speech at the US Congress. He said, consumers by definition include us all. 1962. And when he said this speech in 1962, the whole world was, the consumer movement was not going at all. This is the speech which triggered the consumer movement in the whole of the world. What he said, you just see, consumer by definition include us all. They are the largest economic group in the economy, affecting and affected by almost every public and private economic decision. But they are the only important group whose views are often not heard. And you know, this speech, it triggered the consumer movement throughout the world. Farmers, you know, the farmers need to purchase many things. The farmers need to purchase fertilizers, seeds, okay, the agriculture equipments. The farmers, you know, act as a consumer also. So farmers, they need to know about the law relating to consumer. Okay, just I have made an attempt, because Consumer Protection Act, I don't think it is included in your, that this has not been included. So this that I have made an attempt. You know, this is what I'm saying is the Consumer Protection Act 2019. You know, the under the Consumer Protection Act 2019, the consumer courts are established at 3 different tiers. At the district level, there is a district commission, and the district commission can take up the cases up to 1 crore rupees. If a farmer purchases a tractor, okay, he purchased a tractor, and tractor came out to be defective, or the after sale service is not being provided as promised by the seller, then the farmer can file a complaint at the district commission. If it is a matter is up to 1 crore, then the district commission, in every district this facility is there. Every district this facility is there, and he can file complaint in the district commission. Okay, and the district commission, you know that तारीख पे तारीख matter नहीं है. The district commission is under an obligation under the Consumer Act 2019 to dispose the case within 3 months. Legal obligation 3 months when if the case doesn't involve any lab testing, etc., then the matter can be disposed within 3 months. It shall be, you know, the word shall. होना ही पड़ेगा 3 months. If अगर नहीं हो रहा है, तो it's a violation of law. The matter has to be disposed. If you go to the civil court for this matter, it will carry to 20 years, 10 years. But if you go to the consumer courts, district commission, then within 3 months, the district commission is obliged to dispose the case. Okay, and you know, if the aggrieved party is not happy with the district commission decision, okay, then he may approach to the state commission. In every state, there is one state commission. In every state, there is one state commission. And the aggrieved party may approach to the state commission through appeal within 45 days from the date of the order of the district commission. So as I say, now coming to the state commission, in every state there is a state commission. And if the purchasing limit go beyond 1 crore, but within 10 crore, अगर 1 करोड़ से ऊपर है और 10 करोड़ तक है, तो district commission has no jurisdiction to try this. The matter will come to the state commission. If the farmer has purchased that something or that the financial matter involves more than 1 crore, then the matter will come to the state commission has the jurisdiction. Okay, the state commission has the jurisdiction. And if the state commission, if any farmer will agree from the decision of the state commission, then he will approach to the national commission at the India level, a single one, within 30 days from the date of the order. Now, national commission, there is one national commission of consumer established at New Delhi. And if the financial jurisdiction, if the pecuniary jurisdiction beyond 10 crore, 10 crore se upar hai, the state commission cannot take the cognizance. It will be cognizable by the national commission, National Consumer Commission. And if any person will agree by the decision of the National Commission, then the last remedy that he may prefer an appeal to the Supreme Court of India. He may prefer an appeal to the Supreme Court of India. You see, the farmers, they need to know. Tractor आया, खराब हो गया, और सेलर आफ्टर सेल सर्विस नहीं दे रहा है. फार्मर्स कहता है कि भाई मेरा लक है, मेरा ग्रह नक्षत्र ठीक नहीं है. वो क्या करता है, जाके वो अंगूठी पहनता है, वो डिफरेंट रत्न का पहनता है, हवन कराता है, पूजा कराता है. लेकिन कंज्यूमर नेशनल डिस्ट्रिक्ट कमीशन नहीं जाता है, बिकॉज इट डजंट नो दिस. द फार्मर्स दे नीड टू नो. Okay, because all are consumers, including the farmers. You know, environmental issues. It's a very crucial issue. You know that now it has been well settled that farming and environment, they are closely related. Farming and environment, they are closely related. Evidence आपको अभी पता चल गया होगा. The last unprecedented rain in this week, the unprecedented rain in northern part of this country, आपकी धान की फसल पूरी आपके खेत में है और पूरा बारिश आ गया. Unprecedented rain, that has changed the climate of farming और environmental awareness of वो जुड़ गया है. Intrinsically they are related. You need to aware about the environmental hazards. You need to know about the that the reason of environmental change, the reason about the climate change, unprecedented rainfall, and government policies, schemes, and reforms have started promoting environmental sustainability with a focus on climate resilient agriculture and appropriate adaptation strategies. That we have to adapt, you know, the climate, that we have to adapt according to the climate change. The National Mission on Sustainable Agriculture is one of the 8 missions under the India's National Action Plan on Climate Change, seeks to address sustainable agriculture in the context of risks associated with the climate change by devising appropriate adaptation and mitigation of strategies with special emphasis on this: soil and water conservation, water use efficiency, soil health management, development of rain-fed areas. Okay, and you know now these are the areas on which our government is working. Okay, now national initiatives what are being made in on climate resilient agriculture network project of the Indian Council of Agriculture. You might be knowing this. It aims to enhance resilience of Indian agriculture or adaptation. What I said, adaptation to climate change and climate vulnerability through strategic research and technology demonstration. Okay. This is also one of the that Yojana project, which every farmers should know, that is Pradhan Mantri Krishi Sinchai Yojana, national scheme that aims to achieve convergence of investments in irrigation at the field level and expand the cultivable areas under assured irrigation, because the scarcity of rain due to the climatic change. This scheme is very important. The district agriculture contingency plan, which aims to manage serious weather events. The farmers, they need to know this, what happened in that a couple of days in the past, unprecedented rainfall, and there is a district agriculture contingency plan, okay, which can give remedy to the farmers for this climatic changes. Now this is another law. I don't think this has been covered in your the themes which I have seen. That is the right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. You know that you might have witnessed many cases, okay, many cases in the past about the land acquisition, okay, the conflict between the government and the farmers relating to land acquisition. Okay, now in Singur, the Tata project, the Tata Nano project in Singur, okay, it failed. Okay, Nano project failed after a great tussle was made between the government and the farmers. Okay, and many projects in the state of Odisha, and uh, in all these cases, you might be knowing that the what the farmers said, okay, the Tata Nano, okay, that we are not our most fertile land, that we'll give our fertile land, and in lieu of that, what we'll get? That you will rehabilitate us, you will give the land at somewhere else. It may not be that much fertile, and so we are not agreeing. So this is a very, there is a in most of the cases there is a conflict between the government and the farmers relating to this land acquisition matters, and most of the things, the very brief I will mention this. And as you know, the aim and objective is this Act of 2013 is to acquire land for public purposes. Acquire land for public purposes. And what is public purpose? Very confusing, very debatable, and disputed. Okay, establishing a nano factory in the lieu of the fertile land. Okay, and how far it will serve the public purpose. Okay, is very disputed one. Public purpose. The government can now, but 2013, earlier acquisition, land acquisition, the British land acquisition, it was an authoritarian one, carrying many disputed provisions. But 2013 Act land from the past and made significant changes in the Land Acquisition Act, and the government can, under the new act, the government can expropriate land in the favor of public-private partnership projects that serve a public purpose, provided prior consent at least 70% of the affected landowners. Private companies that serve a public purpose consent at least 80% of the affected landowners. And public purpose is always debated, and it will remain always debated. Include defense, infrastructure development, urban and rural development, and so on. And what is important is that definitely the farmers need to know about their rights, particularly the right regarding compensation, because this act, it gives a method to calculate the compensation. Okay, because the displaced person, farmers must be adequately compensated, and there is a rule, there is a formula to calculate the compensation under this act, and this act also provides for measures for rehabilitation and resettlement, and the farmers, they need to know about this law in case they are being displaced for, under land acquisition. Then they may claim, they may assert their rights under this 2013 Act. Under the 2013 Act. Now, that is As I said, uh, uh, this is the Uttar Pradesh Land Revenue Code 2006. Particularly, I've already told you that land law is a state subject, and every state every state has its own land law. It is not possible to discuss the land law of every state. So I have chosen the Uttar Pradesh Revenue Code 2006, and that we need to know that there are some provision about which the farmer they need to know, and there is a great deal of ignorance about the land law. And very surprisingly, that the lawyers who are practicing in the court and they are practicing in the land matters, they have shown their ignorance that in these points. So I have chosen some very important points from the Revenue Code 2006, and definitely you will agree with me that every farmer they should know, because this has not been covered in your curriculum.
Thank you very much, sir, for your nice presentation and quite enough in-depth analysis and presentation. And now this is open for question and answer. I am unmuting all of the participants. So please, you can, if you have any question, you can unmute yourself, and then you can ask the question.
Ranjan from Farmisto, and thank you, sir, for your valuable inputs on so wide varieties of agricultural laws.
Thank you, sir.
I was just keen to know if there are some laws regarding toxicity, residual toxicity of pesticides and very many agrochemicals, plant production chemicals which the farmers use, and with increasing use it's becoming a menace so many days. Should the farmers, if it is, how should the farmers be aware, and what are those rules and laws? Thank you very much.
I have particularly worked on, and particularly in my deliberation in my lecture, I briefed these laws, what are included, what are that is escaped, what are not adequately covered under the various themes, proposed themes. I think there are various law relating to fertilizers. Okay, and that application, and I have already that if you Pesticides Act, I mentioned 1968. Okay, and there is an amendment also. There is a recent amendment in the Act, and if you that again, it is if you noticed, let's say. This is Insecticides Act 1968 and Insecticides Rules 1971. And now this act has undergone an amendment in 2000, and this is popularly known as the 2000 Act. Okay. Yes. Next, please.
Yeah, but what does it say about? I think this Insecticide Act you are talking of and the FCE Fertilizer Control Order you are talking of, these acts only talks of the sales and distribution and purchase and storage and transportation of these chemicals. I am talking of the residual toxicity because of these chemicals in the in the crops, in the produce which farmers are selling.
Yes, sir. I got your point, sir. I got your point, sir. And the Food Safety and Standards Act 2006. The Food Safety and Standards Act 2006, under which a Food Safety and Standards Authority is established, and particularly this act is empowered to deal with these matters.
Okay, Dr. Manisha Narayani there. I hope she will throw some light during her session.
Okay.
Okay, thank you, sir. Thank you very much.
Thank you, sir. Thank you, sir. Thank you so much.